All those in favor say yes. Yes. All those opposed, no.
No.
Opinion of the chair, the ayes have it, and the resolution is ordered to be reported favorably to the House. Members will have 2 days to submit views without objection. Do you want a roll call?
There wasn't. Roll call, please.
Roll call being requested. The clerk will call the roll.
Never mind.
Roll call being withdrawn. The resolution passes, and the resolution is ordered to be reported favorably to the House. Members will have 2 days to submit views without objection. Staff is authorized to make technical and conforming changes. We need Mr. Fitzgerald. Harriet Scott, okay. Pursuant to notice, I call up H.R. 288, the Separation of Powers Restoration Act, for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 288.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentlelady from Wyoming, Ms. Hageman, for an opening statement.
Thank you, Mr. Chairman. I strongly support Representative Fitzgerald's Separation of Powers Restoration Act, and I'm proud to be a co-sponsor of this important legislation. Judicial deference is a harmful doctrine placing the American people at a distinct disadvantage in court when going up against what has become an all too powerful administrative state. Separation of powers is the foundation of our Constitution, guaranteeing our right to a Republican form of governance while checking the tyranny of mandates by fiat. The modern administrative state stands in stark contrast to this model, and the creation of the deference doctrines has only further upended this separation of powers, pursuant to which federal agencies oftentimes not only diminish, but sometimes outright ignore congressional intent, with deference then allowing them to also infringe on judicial review. So I want to thank Mr. Fitzgerald for offering this bill to level the playing field by requiring courts to use de novo review of all relevant questions of law and to discontinue our judicial branch's willingness to allow unelected bureaucrats to do their jobs. I also believe it is important to clarify the intent of this legislation. Providing for de novo review of all relevant questions of law, including the interpretation of constitutional and statutory provisions and rules made by agencies, as the bill outlines, is not intended to be a limiting statement. It cannot be a limiting statement if we are to fulfill our goal of reining in the administrative state. This means addressing the array of issues that may arise under the Administrative Procedure Act. One such issue is the question of agency guidance, described as informal, non-legislative rules or documents which constitute an agency statement of general applicability intended to have future effect on the behavior of regulated parties that set forth a policy on a statutory, regulatory, or technical issue, or an interpretation of a statute or regulation. These forms of guidance don't follow the notice and comment requirements of the APA and don't have the force of law. Yet we have seen a growing trend whereby administrative agencies attempt to use guidance to make new law while at the same time avoiding the APA process, and then argue that such guidance is not reviewable by the courts because it does not constitute final agency action. They compound the problem by then seeking to have the courts defer to their opinions in that regard. Because guidance is, by definition, intended to guide something related to a statute or regulation, it must also be subject to de novo review under this bill's language. It is for this reason that this bill is not limited in scope. It follows from the text of the bill, and it is the intent behind the bill that judicial de novo review of all relevant questions of law includes questions of law surrounding agency guidance. If we are to carry out the mission the American people tasked us with when they gave us the majority, which includes reining in the abusive federal agencies, we must include the growing area of abuse as represented by agency guidance. The fact is that deference unfairly pits the administrative state against the American people. It further undermines our rights by distorting the intent of the laws as written by our elected representatives. It also undermines the very purpose of judicial review by creating systemic judicial bias in favor of administrative agencies, which at this point in time have become far too powerful and far too dictatorial in their actions. Correcting this harmful construct of deference to agencies, including the guidance that they issue, is one of the most important tasks we can take on, and this is an important piece of legislation. I am proud to support this bill and urge all of my colleagues to do so as well. I also request unanimous consent to introduce an article published in the Wall Street Journal on May 9th, 2023, entitled "The Deep State is All Too Real," written by former DOI Secretary David Bernhardt. Thank you, Mr. Chairman, and I yield back.
The lady yields back. The chair now recognizes the ranking member, Mr. Nadler, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, H.R. 288, the so-called Separation of Powers Restoration Act, would completely upend the administrative process by eliminating judicial deference to agencies and requiring federal courts to review all agency rulemakings and interpretations of statute on a de novo basis. More than 30 years ago, the Supreme Court held in Chevron USA, Inc. versus Natural Resource Defense Council that courts must give, quote, considerable weight to an agency's construction of a statute it administers. This makes sense because while Congress sets broad policies, we delegate authorities to executive agencies because we do not have the expertise to craft technical regulations ourselves. We do not have the expertise to decide how many parts per billion of arsenic in the atmosphere is safe, or how many parts per billion of lead from automobile tailpipes in the air is safe. Under the Chevron doctrine, courts respect the careful process undertaken by the dedicated professionals at our federal agencies, many of whom have decades of experience and vast technical expertise. And they give deference to an agency's interpretation of its statutory authority if the interpretation is determined to be reasonable. The Chevron doctrine has been the ruling precedent for judicial review of agency decisions for decades. It rests on the presumption that Congress intended to task agencies with enforcing the laws and carrying out the policies that Congress passed. It is therefore in the hands of Congress to change any presumption of legislative intent. But instead of taking a careful and deliberate approach to provide more guidance to agencies and thus reviewing courts as to what Congress wishes agencies to do, the majority is using a broad bill to undermine a long-standing precedent set by the Supreme Court, a move that would throw uncertainty into the entire rulemaking process and grind courts' review of agency action to a stop. In addition, this bill would empower judges to completely override the determinations of agency experts and to substitute their own judgment, regardless of their comparative lack of technical knowledge and understanding of the underlying subject matter. Thus, this legislation would put consumers in danger by allowing a judge to undermine and second-guess the carefully crafted and scientifically based decisions by agencies. It is a height of hypocrisy for the party that rails against what it calls judicial activism to support legislation that is the very embodiment of judicial activism. By eliminating judicial deference to agencies, this bill would empower the courts to make public policy from the bench, ignoring the careful consideration and technical expertise of executive agencies. H.R. 288 would also make the federal rulemaking process even more time-consuming and costly. As leading administrative law experts have found, the current process of agency rulemaking takes considerable agency time and resources. By eliminating deference to agencies, this legislation would exacerbate this problem by forcing agencies to adopt even more detailed factual records and explanations in order to withstand judicial scrutiny, which would further delay the finalization of critical life-saving regulations. These are regulations that protect the quality of the air we breathe, the water we drink, the food we consume, and the safety of the products we use. Slowing down the rulemaking process for these vital health and safety protections would put the lives of Americans at greater risk. H.R. 288 could also have the perverse effect of undermining the agency rulemaking process in favor of corporate interests. As the Nonpartisan Congressional Research Service has observed, public participation in agency decision-making is highly sensitive to cost and delay. By imposing greater scrutiny of agency rulemaking, the bill would skew the fact-finding process in favor of those with significant resources. Large corporate interests devoted only to maximizing profits for the benefits of shareholders already have the edge in this process with their vast resources to weaken regulatory standards by burying an agency with paperwork demands and litigation. Rather than giving more opportunities for corporate interests to prevail, we should be evaluating ways to ensure that the voices of the public have a greater role in the rulemaking process through proposals like the Stop Corporate Capture Act, which would bring more transparency and more accountability to the rulemaking process. This legislation is just the latest step in the Republicans' decades-long assault on the regulatory process, trying to add hurdle after hurdle on the ability to issue regulations that protect public health and safety. Regulations whose benefits consistently outweigh their costs, often by many multiples. I urge my colleagues to oppose this dangerously flawed legislation, and I yield back the balance of my time.
Gentleman yields back. The chair recognizes the gentleman from Florida. Oh, excuse me, that's right. We have a amendment, nature of substitute. I want to go to Ms. Hageman. I apologize. The gentlelady from Wyoming is recognized.
Thank you, Mr. Chairman. This is an amendment in the nature of a substitute, and I have an amendment at the desk.
The clerk will report.
Amendment in the nature of a substitute to H.R. 288.
Without objection, the amendment nature substitute will be considered as read and shall be considered base text for the purpose of the amendment. The chair now recognizes the gentlewoman from Wyoming.
This amendment provides that the Separation of Powers Restoration Act of 2023 may be cited by its acronym, SOPRA, S-O-P-R-A. This change more readily allows this bill to be cited by its commonly known acronym when it is passed into law, and it is not intended in any way to alter the important purpose of this bill. I urge its adoption, and I yield the balance of my time. Thank you.
Gentlelady yields back. Who seeks recognition? Gentleman from Florida is recognized.
Thank you, Mr. Chairman. I used to believe exactly what my colleague from Wyoming used to believe about this legislation, and I used to believe it for exactly the same reasons that she laid out, because it is true that concerns about a growing administrative state are ones that are commonly held throughout the country and certainly commonly held by a majority on this committee. But I have encountered a good amount of conservative scholarship that defends the Chevron decision, which is really what this legislation would overrule. The Chevron decision set forth the principle that in the absence of an ability to determine congressional legislative intent, that rather than the court starting from scratch, that there would be some deference, not unovercomable, but some deference given to the agencies. And the late Justice Scalia wrote very strongly in defense of the Chevron legislation and against the Chevron decision and against what this legislation would bring. And he spoke specifically to this matter, and he said it far better than I could, so I'll read from the late Justice Scalia's writings on this matter. Quote, "The extent to which courts should defer to agency interpretations of law is ultimately a function of Congress's intent on the subject as revealed in the particular statutory scheme. An ambiguity in a statute committed to an agency implementation can be attributed to either of two congressional desires. One, Congress intended a particular result but wasn't clear about it, or two, that Congress had no particular intent on the subject but meant to leave the resolution to the agency. When the former is the case, what we have is genuinely a question of law properly resolved by the courts. But when the latter is the case, when we have a conferral of discretion upon the agency, the only question of law presented to the courts is whether the agency has acted within the scope of its discretion." And Chairman Nadler is entirely correct when he talks about the critique on the right of judicial activism running right up against the ideology that undergirds this legislation. You cannot critique judicial activism, as so many on the right have done for decades, and then say, but what we really want as a result of SOPRA is a more activist judiciary. Scalia continues, "In the vast majority of cases, I expect that Congress neither, one, intended a single result, or two, meant to confer discretion on an agency, but rather, three, didn't think about the matter at all. If I am correct, then any rule adopted in this field results from a fictional presumed intent and operates principally as a background rule of law against which Congress can legislate. If that is the principal function to be served, Chevron is unquestionably better than what preceded it. Congress now knows that the ambiguity it creates, whether intentionally or unintentionally, will be resolved within the bounds of permissible interpretation, not by the courts, but by a particular agency whose biases are well known. Scalia writes, if we have to serve up these questions to an entity other than Congress, at least with the agencies, there's a greater degree of predictability with the courts. And that is no defense of the agencies so much as it is a critique of the federal court system and the disparate outcomes that can be created. In Scalia's piece, he also talks about the need for government flexibility and observes that if the court always has to overrule itself, it does so very begrudgingly in frequent circumstances, whereas agencies admitting they get it wrong is not wrong as to a de novo question of law, but wrong as to a particular series of events. And Scalia opines that government is better served under that observation. There's also substantial historical basis for Chevron. You even had Hamilton writing about the importance of energy in the executive. Madison at the Constitutional Convention talked about this argument. He said that when choosing between the executive and the judiciary, quote, the former must get greater latitude than the latter in the administration of the country. And so if that is the case, there's historical precedent. I know the newfangled concern of conservatives is the growing administrative state, and I share that concern, but I think that we don't disagree on the problem. I think just as Ms. Hageman laid it out, she perfectly laid out the problem, but I think the antidote to the problem isn't to overrule Chevron, it is to do a better job in Congress of being clear as to our intent and then to leave fewer of these decisions to these ambiguities. I yield back.
Gentleman's time has expired. I think the gentlewoman from Texas.
Some say that Texas and Florida has much or some in common. I hesitate to go there because my good friend knows that there are challenges in Florida that I cannot counter. He might have something to say about Texas, but we overcome it with good barbecue. But I must say, as the gentleman has enunciated some principles that I think are extremely valid, I would take his last sentence, maybe we need to be better at clarification. But the Administrative Procedure Act has been implemented since 1946. And we have been able to live under the APA. In fact, I remember one of my less interesting but very vital classes in law school was the Administrative Procedure Act that gave a basis for the complementary aspect of government that fits alongside of executive orders, judicial decisions, legislative actions in the United States Congress. And so to weaken that construct that has added to the democratic process of this nation is the direction in which I would like to go. And it seems to me that the gentleman from Florida has made even further advocacies, including the Chevron case, that there is value to not having a protracted judicial review of an administrative procedure action that may have taken quite a bit of extensive writing, research, and yes, the input of the American people. As you well know, once you put a regulation out, there is a period of time, 30, 60 or more days, and even gets extended, for there to be comment. In that instance, the comment is not Republicans and Democrats, it's everyone, including those who are specifically impacted or engaged in the particular topical issue. So the Department of Energy can have, if you will, regulations, and the energy industry participates and provides insight and light to whatever the issue is. Some person could be where they want to challenge it, and if we loosen or lessen the deference to that process, then we have protracted, long judicial proceedings. I think that what is being attempted to do here is one that we should hesitate. Now, I don't want to scare away persons who may be supporting the theory and thesis of my good friend from Florida, but I'm obviously in the corner of the Food and Drug Administration's long years of having a particular pill that did not harm anyone. And they did it on their research. They did it through their processes. It was open to the public comment. I assume medical professionals at that time, pharmaceutical industry might have commented at that time. And we've come full circle because we've got ourselves in the quagmire of trying to interfere with a private choice and a religious choice and an emotional choice and a medical choice by women of this country. We call that reproductive rights. But it may come up on many other issues. And this does not negate the purpose for judicial review. I think what this legislation is doing, as I read it, it is extending what we're looking to do is to not have the courts to go de novo on a matter that has been thoroughly researched and approved by an administrative process. Some of the agencies have boards. They have appointees that come from both sides of the aisle. And so it's been vetted in that way as well. Rules by agencies and constitutional and statutory provisions are all part of this process. So I would make the argument that I don't know if we want to add yet another layer of interference with the necessary operation of government that has already been accused of not being timely, being dilatory, being delayed, when we can take the effective work of our agencies, Centers for Disease Control issued some rules that, from my perspective, save lives. Food and Drug Administration has been the stellar agency internationally. A drug gets its star points when it gets the FDA's approval, and the world watches that happen. So I'll conclude my remarks, Mr. Chairman. Your generosity is that I believe that this legislation goes too far in impacting negatively the running of government. I ask
Gentlelady's time
opposition,
has
yield back.
expired and yields back. The gentlelady from Wyoming is recognized for 5 minutes.
Having been a practitioner for over 30 years and having many cases against federal agencies, I can assure you that the courts have moved well beyond deferring to regulatory agencies in ambiguous situations. I'm going to read some of the language from the Rapinos decision that was issued by the United States Supreme Court in 2006 as a way to emphasize this point. According to the decision in that case, the burden of federal regulation on those who would deposit fill material in locations that are denominated as navigable waters of the United States is not trivial. In deciding whether to grant or deny a permit, the U.S. Army Corps of Engineers exercises the discretion of an enlightened despot, relying on such factors as economics, aesthetics, recreation, and in general, the needs and welfare of the people. The average applicant for an individual permit spends 788 days and $271,596 in completing the process, and the average applicant for nationwide permits spends 313 days and $28,915 in seeking permits. The enforcement proceedings against Mr. Rapinos are a small part of the immense expansion of federal regulation of land use that has occurred under the Clean Water Act without any change in the governing statute. I will repeat that, without any change in the governing statute. During the past 5 presidential administrations, in the last 3 decades, the Corps and the EPA have interpreted their jurisdiction over the navigable waters of the United States to cover 270 to 300 million acres of swampy lands in the United States, including half of Alaska and an area the size of California in the lower 48 states. And that was just the beginning. The Corps has also asserted jurisdiction over virtually any parcel of land containing a channel or conduit, whether man-made or natural, broad or narrow, permanent or ephemeral, through which rainwater or drainage may occasionally or intermittently flow. On this view, the federally regulated navigable waters of the United States include storm drains, roadside ditches, ripples of sand in the desert that may contain water once a year, and lands that are covered by floodwaters once every 100 years. Because they include the land containing storm sewers and desert washes, the statutory navigable waters of the United States engulf entire cities and immense arid wastelands. In fact, the entire land area of the United States lies in some drainage basin, and an endless network of visible channels furrows the entire surface, containing water ephemerally wherever the rain falls. Any plot of land containing such a channel may potentially be regulated as a, quote, navigable water of the United States. Why do I read that? Because courts have been deferring to that nonsense now for decades in terms of the immense expansion of the EPA and Corps of Engineers authority over what is defined in the Act as a navigable water of the United States. How have they been able to do that? Because the courts have been abdicating their responsibilities of deciding questions of law de novo, and they have allowed the agencies to make those decisions. That's why this act is so important, the Separation of Powers Restoration Act of 2023. I can understand what my colleague is saying about the concerns of courts making the decisions, but we're not talking about activist judges actually doing their job if they are reviewing statutory and regulatory documents, laws de novo. It is when they defer to the agencies that they fail to do their jobs. Having been someone who has tried numerous cases against the EPA, for example, or the Corps of Engineers, or the USDA, or the Forest Service, or Fish and Wildlife Service, I can assure you that when I represent farmers and ranchers, oil and gas companies, other resource producers, and small businesses, when I walk in the courtroom because of the deference doctrine, typically what you're seeing is that I've already lost the case. And then what I have to do is overtry it because of the deference doctrine. So what the deference doctrine actually does is it places the thumb on the scale of the administrative agency against the citizens of this country, the exact opposite of what is the foundation of America and what is the foundation of our form of government. We don't work for the government works for us. Yet with the deference doctrine, what has happened is these administrative agencies have taken over so much power and authority simply by claiming that a statute or a regulation or even now a guidance document is ambiguous, and therefore they must be the ones to interpret it, and the courts need to stay out of it. This is a good bill. It serves a great purpose of putting the regulatory agencies back in their lane, of only carrying out the law as Congress wrote it, not actually interpreting it as our judicial branch is required to do. With that, I yield back.
Gentlelady yields back. The gentleman from Georgia is recognized.
Thank you, Mr. Chairman. I rise in opposition to this legislation. There's a reason why Republicans have been about packing the United States Supreme Court over the last 40 years, over the last 50 years, to the point now where they have a 6-3 supermajority of right-wing Republicans on the bench ruling in favor of corporations. The reason why they wanted to pack the court is so that they could pass legislation like this, which puts it in the hands of the United States Supreme Court to rule on agency rulemaking, to be a super rulemaker, in other words, to put the Supreme Court in a position to decide what is best for the health and safety and well-being of Americans through oversight of regulatory authority. The FDA, for instance, Food and Drug Administration, when they issue a rule that would protect the health, safety, and well-being of Americans, and they do that, let's take mifepristone, for example, a drug that induces miscarriages in women who are in need of that medical procedure. They want a court that is empowered to overrule the agency rulemaking process and rule that that medication is not efficacious without any support, without any factual basis, without any expert factual basis. They want to put the court in a position to do that. And the court is basically packed at this point and awaiting congressional passage of legislation like this so that they can do exactly what I said to do, and which is to overrule agency rulemaking that will protect the health, safety, and well-being of Americans. That agency rulemaking is based on laws passed by Congress, laws that, and I'll point out the fact that if you expect every rule to be mandated or passed by the House of Representatives and then the Senate and then the President, we basically would have no rules. It would be a free market economy with no rules or regulations to protect the people. This is what the Republicans want to accomplish in this country. They want to do away with government. That's why they talk about less government, defund the government. They want to reduce the size of government to the point where you can strangle it in the bathtub. That's why they have all signed on to the Grover Norquist no new tax pledge. And so, you know, they are killing us. They're killing us, literally, with their pursuit of free market capitalism so that the rich get richer, the poor get poorer, and there's no protection for the little guy, for the health, safety, and well-being of the little guy. So this legislation I oppose. It is a race to the bottom of our democracy for capitalism to take hold of freedom and to drive it into the dirt. That is what this kind of legislation does to our living here in this country. It's very destructive, and it seems to be increasing its stranglehold. First, you have Republicans who control the House offering legislation. Next, they will want to control the Senate so that they can pass this legislation and then send it to the courts, which they have packed, which are then in position to do away with all regulations to protect health, safety, and well-being of Americans. Dangerous road to go down. Let's not do this. I oppose this legislation, and I yield back.
Gentleman yields back. Chair recognizes himself. I don't want to do away with government. I just want those who are elected to office by we, the people, by the American citizens, to actually make the laws. Imagine that. But that's not what the Democrats want. That's not what they want. They want to defer to the bureaucrats. That's what Mr. Nadler said in his opening statement. He said, quote, "We don't have the expertise." Well, who does? The unelected bureaucrats? The people in the agencies who never have to go out, shake hands, talk to the American people, get elected to office? The people who aren't elected by the American people? I mean, leave it to the experts, the Democrats say. Well, who's the expert who ran our lives? I've talked about this a lot because it drives me crazy. Who's the expert who ran our lives for the last 3 years? Who's the expert? Served longer in our government than anyone else. The bureaucrat is Dr. Fauci. Dr. Fauci, the smartest man on the planet, never been wrong, except in just about everything he told us about the virus. Remember when Dr. Fauci said it wasn't our tax money that went to that lab in China? Wasn't right about that one. Remember when he said it wasn't gain-of-function research? Wrong about that one. Remember when he said it didn't come from a lab? I will not. Remember when he said it didn't come from a lab? Sure looks like it did. Remember when they told us the longest-serving bureaucrat in the government, the smartest man on the planet, told us that the vaccinated couldn't get it? Remember when he told us that? Remember when he told us the vaccinated couldn't transmit the virus? Then he told us there's no natural immunity. First virus in history. No natural immunity. That from the expert. So while I appreciate the arguments from Mr. Gates, and I think he makes some good points, and I think there is a balance here when we're talking about the courts and the agencies, what bothers me the most and why I support the gentlelady's legislation is because I am so tired of this argument that we got to leave it to the experts, the bureaucrats who know more than the folks who actually go out and talk to the American people, put their name on the ballot. In the case of Congress, every 2 years put their name on the ballot and get elected to office. They should be making the decisions. Yield to the gentleman from New Jersey.
Chairman, I want to agree with you, and I agree with the lady's legislation very much. I got to tell you, I've had the, I guess, experience of being a state senator, a state assemblyman, a county commissioner, a mayor. I've dealt with a lot of regulatory agencies, more than most people in Congress, to be honest with you. And to say that they always do a better job, they're often very slow, very bureaucratic, very opinionated, not by any means always right. And Fauci, you used the example, which is the best one of all. And on top of all the things that they do, this is not the same regulatory agencies that we were used to when this process was started many years ago. Many of them are tied to politically and involved with politically people who want to get a certain outcome. And I've seen it, Chairman. I've seen it over and over again where they desire to have a particular outcome. They work within the agency. And if you don't think that our president right now has effect on the agencies and what they're saying or doing, or that other people don't in positions of authority, you're wrong. It's an imperfect system. I don't love the courts either, to be honest with you, at all times, but at least there you have a fair and expeditious chance to be heard and to have some say in what the ultimate result is going to be. So after the literal pain I've gone through dealing with these agencies, and it could be DEP, which is the EPA of New Jersey, or it can be the EPA, or it can be the health organizations. And by the way, some of the examples that are used, these folks have made horrific mistakes. They've made terrible mistakes. So in a court of law where you may have experts come and speak on both sides of an issue and intelligently thrash it out, I think that there's value to that. And I think we should really see that value. And finally, yes, Congress should do a better job. One thing, legislative intent. We want to have legislative intent where we really get something done, but we get it done the way that we envision it. These agencies change it. Our legislative intent, over half of the time, is not the legislative intent that they see and they feel and that they enact. So I think it's time we did something like this. I support your bill.
Will the gentleman yield?
15 seconds.
One can disagree with this bill and certainly not agree in deference to the agencies in every circumstance. I would simply offer that bills like the REINS Act, which we've debated in this committee, might be better antidotes to the problem.
We plan on bringing that. That's a great point from the gentleman from Florida. We do have votes that have been called on the floor. I understand there are 3, and I believe I've been told that we're getting a picture today. Is a picture day today? So the committee will recess because I understand the Democrats have some amendments they want to offer to this legislation. I think that's accurate. Okay. So we will recess, and we will get a notice out to when we're going to come back. I want to talk with members and see what they have this evening. So we will probably come back this evening, but it may be tomorrow. I just want to check with our members, and I'll check with the ranking member as well. So with that, the committee stands in recess.